Good afternoon, everyone. Welcome to day 8 of the Modiragatsi competition. You feel like family by now, so I feel a lot less stressed to welcome you here in my home this afternoon. So I hope that you enjoyed working on intellectual property today. We have a treat for you in store in terms of the amazing content that Kesh IP have developed for you. So this afternoon we will have a broadcast of the intellectual property content that they created. And after this presentation, you will be able to specifically answer or complete activity 5.1 in your training. Remember, activity 5 or topic 5 is intellectual property, is the second last topic that you will be encountering in this training. Tomorrow we'll be looking at how to start a business with your idea, and on Thursday and Friday, then you will spend all of your time then working on finalizing your submission, your short report, and your video needs to be submitted by Sunday for the final judging. If you haven't done so already, please remember to register for the Femgineering event. Femgineering event will take place from 9 to 13 August right here on YouTube live stream. The first 200 girls to register will be able to receive a very nice fully loaded goodie bag. So make sure that you click on the link, that you register for the Femgineering event, and that you'll be able to get your goodie bag. We will also be releasing the list of the speakers and the different activities over the course of the next few weeks as we run up to the 9th of August. Apart from that, speaking about goodie bags, the goodie bags have left Potch today, so you should receive a tracking number or an SMS with your tracking information by tomorrow, and I hope that you will start receiving your calls Friday morning or maybe over the weekend. Apart from you taking a picture for us in your apparel that I sent you, I will also be asking you tomorrow to submit one head and shoulder photo of yourself in your school uniform that we will use in the announcement of the top five candidates in each category. So make sure that you take a nice picture tomorrow in your school uniform and send it via direct message to your group admin, so that once we make the announcement, we have all of the photos ready so that we can share that on social media as well. Remember to share on social media the excitement that you feel, especially about this topic now while we're watching. So this is a good idea to now share your ideas and your enthusiasm about the value of your ideas. So without any further ado, let's move to the broadcast of Kesh IP's content. And then also remember that you can ask all of your questions in the live chat, just like any other day. Izan and Ursula will answer them in the live chat text. So ask your questions, and any questions that are not IP related, I will answer live after the 50-minute broadcast. So let's watch the video now.
Out of nowhere, ideas are sparked. In the silence, inventions take form. And over the horizon, they come to life. The light bulb, the telephone, or the wheel will forever define a changing of the guard, a world ignited by ideas and passionate people. The pioneers and the inventions they so carefully crafted reshaped our world and revolutionized all that had come before. And as they did so, a new way of thinking was born to protect ideas and the people that created them. A law firm stepped forward, spurred on by the vision of a man with the foresight to know that intellectual property must be protected. We are Kish IP.
I'm your host for today. I'm the head of the patent department at Kish IP. I specialize in chemical and petrochemical, biotech, and pharmaceutical-based inventions. I have a honors in chemistry from previously Rao and now UJ-University, as well as an LLB. I've been working at Kish for the past 16 years and one of the partners at the firm.
So I'm Azan Kushka, like Ursula said. I'm a senior associate here at Kish IP, also in the patent department. I'm more into the patent litigation field, so I run to court more often. So I take Ursula's inventions and I go enforce them, basically, if there's somebody that's not obeying the monopoly that has been granted to our clients. So I'm in a bit more of the trenches of IP, so to speak. I studied genetics and thereafter did my LLB degree. I specialized mostly in life sciences, forensics sciences, and the like.
Wonderful. So let's see what we're going to be discussing today. We're going to take you through some of the females in IP and look at some of the first innovators in the female space. We're also going to look at what is IP and following that delve a little bit deeper into the types of IP. For instance, we're going to be looking at patents, we're going to be looking at designs, trademark, as well as copyright. Okay, so let's look a little bit into what actually has been created by females in the IP space and look at some of the key innovation that's been taken place by females worldwide. So if you've been involved with Wi-Fi, which I'm sure we all have, especially during these lockdown times, if you have windshield wipers, even if you use a dishwasher, or even played Monopoly, which I'm sure we all have, you have a woman to thank for all of these great innovative ideas, because they were all invented by women. There are many inventions that we use every day that have been created solely by women. And we're going to take you through a few prime examples of this. With August being the month of celebrating women in South Africa, this is also very key to today's discussion. And it's important to showcase the inventions that make our lives a little bit more easier on a day-to-day basis. One of the key female IP innovators that we are going to look at today is Radia Pearlman. She was a network engineer and had a PhD in computer science from MIT. And she has made numerous contributions to the internet. She has more than 100 US patents to her name. And she really, really holds the lead title in the amount and number of patents that has been filed by a leading female in the world. We can also look at Belua Henry. She is known globally, and they've given her the nickname as Lady Edison, after she obtained 49 patents for all of her inventions, one of which is a very famous ice cream freezing machine.
Very useful, I think.
I think so too, especially for those of us in summer who do like ice cream.
Exactly.
A year later, she received a second and a third patent for a handbag, no doubt.
Fantastic.
As well as for an umbrella, both with interchangeable covers. Very useful.
My type of woman. So the next woman we're looking at is Josephine Cochran. So she's the inventor of, well, I think it's one of the most precious items that I own, the dishwasher.
Absolutely.
Because everybody hates washing dishes, let's be honest. And she obviously also did too, and she made a plan of making something that made this a bit more automatic and less fine china-manship, because we are ladies after all. So she designed a set of wire compartments to fit plates, cups or saucers spinning on a wheel inside a copper boiler with hot soapy water. Thank you, Miss Cochran.
Thank you. I echo that.
Then we've got Miss Mary Anderson. So if it weren't for her, we would be driving blindly in the rain. She designed the windscreen wipers. So with her schematics for an early version of the windshield, she got a patent in 1903. So it's quite far back. So I think just after Henry Ford, she decided, no, this is not working, sir. It's black, it's boring, and I can't drive in the rain. So she got the idea when she toured New York in a trolley car on a snowy day and noticed the driver often had to open his windows to see out. She was probably quite terrified for her life as well.
Absolutely. Sure, thank goodness for her innovation there.
Absolutely.
One of the other key leading IP females of the recent past, Helen Free. She patented a system that led to the dip and read urine tests, and this has been a really key form of innovation, especially in the diabetic field, to detect glucose levels. Well done to Helen. One of the other leading female IP innovators is Dr. Shirley Jackson. She was involved in groundbreaking research and work in the telecommunications field, which has allowed others to invent portable fax, touch-based smartphones, solar cells, fiber optic cables, and technology all behind the caller ID and call waiting technology. So without her, I don't know where our innovation today would be.
Seems almost as if the narrative is that men designed this, but it seems, hey, we've got a lady to thank.
100%.
So then we've got Hedy Lamarr. She is also known as one of the most glamorous stars of the black and white film era. So why are we talking about her during an IP discussion? Well, she was also one of the minds behind an invention that provided the foundation for GPS, Bluetooth, and Wi-Fi technology.
Another smart bean.
Exactly, not just a pretty face. So this Austrian-American actress, Hedy Lamarr, was also a gifted mathematician and engineer, and then when World War II broke out, she wanted to make a contribution to the war effort by improving torpedo technology.
Sure.
So she comes with a twist. So, and also, working with the musician and composer George Antheil, Lamarr developed the idea of frequency hopping, which could encrypt torpedo control signals, preventing enemies from jamming them and sending the torpedoes off course. Although Lamarr and Antheil were granted a patent for the idea in 1942, the US Navy ignored their technology for 20 years, finally putting it to use during the 1962 blockade of Cuba. They could have gone off much better, but okay, the rest, they say, is history. So although since then Lamarr's spread spectrum technology has become the foundation for the portable devices that we use every day, for which she was inducted into the National Inventors Hall of Fame in 2014.
Well done, Hedy. So despite the above achievements, females are still seriously outnumbered when it comes to males, looking at the number of patents that are granted worldwide. The disparity is so severe that in one recent study, it was found that based on the current growth, it will take approximately 118 years before the US reaches gender equality amongst inventors. So there's a saying, strong women, may we know them, may we raise them, and may we be them. So
Absolutely.
I think that's a key motto for today's discussion.
So what is IP? We've briefly discussed what women have done, and you've heard various different types of inventions. They range from the handbag to the windshield wipers, it's to Wi-Fi, and torpedo technology. I mean, it's amazing. So, but at the end of the day, we don't just have patents that form part of intellectual property. For that, we've also got patents, copyright, designs, trademarks, plant breeders' rights, then also your less known IP such as trade secrets, know-how. We'll be discussing the main portions of IP that make it up, and also the different requirements, the scope of protection that they afford, whether they have to be registered, what's the schlep to get IP registered, basically.
Sounds like quite an agenda.
So starting with patents, just broadly saying that the purpose of patents is to protect technical ideas or concepts. So this would include systems, method, processes, devices, compositions. So you can see how it goes from the mechanical engineering field all the way to chemistry, and even my field, genetics. So it's a very broad field at the end of the day that a patent can apply to.
So what do patents offer? Patents offer a limited monopoly, and they are territorial in nature, meaning that if you wish to seek patent protection, you would need to file a patent in each of the countries in which you want your idea, your composition, your system, your process, whatever it is that you're looking to patent, protected. It is a negative right, This meaning that it will exclude your competitors from seeking to do what your patent protects. There are three main requirements for patentability. The first of which is that the idea or concept needs to be new. And looking at this requirement, we look at novelty from a worldwide perspective, meaning that in all of the parts of the world, this invention must not have been made, created, or even disclosed. Secondly, the invention must be inventive. It cannot just be an obvious combination or an obvious thought process that leads you to the invention. It really has to have an unexpected technical effect that puts your invention over the prior art, so to speak. And lastly, the invention must be useful in trade, industry, and agriculture.
So the novelty requirement, we, as Ursula said, we look at it from a worldwide perspective, and we also look at it and we call it absolute novelty, meaning there can be nothing that has ever been disclosed that is part of your invention. So new in the formal and technical slang that we talk is that it can't form part of the state of the art at the date of filing or application for the patent. So all the matter that's been available in the public up to that date will count as prior art or state of the art, and we will have to look at your invention against what was available prior to that date to determine whether it has been novelty, whether its novelty has been destroyed or not. So when we look at the state of the art, we look at printed publications, advertisements or earlier patents. We look at commercial use. Has it been discussed anywhere at conferences even? Has there been tenders that's gone out and awarded for an idea? And even secret commercial use within South Africa counts against you when it comes to determining novelty.
So Izan, does that mean that if I disclose my invention, I can no longer patent it?
No, absolutely not. So if you keep it secret and you do not use it commercially, then you can. So the Patent Act does protect you.
Oh, wonderful. Something to think about. Okay, so looking at the novelty requirements a little bit further, how we normally assess novelty is we break the invention or the concept up into what we call the essential integers. We compare one prior art document against all of these essential integers as to see whether that one prior art document contains all of those essential integers. If that prior art document is missing one of those essential integers, that document cannot constitute prior art against the invention. So it is very, very important when one is looking to create some innovation that you're looking to patent, to do your prior art searches thoroughly and to ascertain whether there is any close prior art. Assess that prior art and ensure that all the essential integers of your invention are not disclosed in that one document. Looking at inventiveness. Inventiveness is a slightly different criteria in that it's more subjective. Whereas novelty is an objective requirement, we can quite clearly see whether a prior art document does or does not disclose the invention. Inventiveness can be a little bit more tricky. And here we look at what we call a mosaic of prior art. So we can put together 2, 3, 4, even 5, 6, 7 prior art documents. And if those prior art documents all read together can lead a person who is skilled in the art, as that is who we're assessing the prior art as the reader, if it is obvious from a reading of all those prior art documents when mosaic together that the invention could be achieved, then of course the invention will lack inventiveness and will be deemed to be obvious to a person skilled in the art.
So the exclusions, the Patent Act does say there are certain things that are not patentable subject matter. These include discoveries, scientific theories, program for a computer, the presentation of information. So but these exclusions are covered by other IPs, so don't need to fret because we do look at it from another perspective, just with other intellectual property protection.
And would that also include perhaps an app?
Exactly, but we have our ways around it.
Oh, wonderful.
So the varieties, further exclusions are varieties of plants or animals that are essentially biological processes for producing a plant or an animal. So this is not microbiological processes or products. And then, of course, the treatments of humans or animals, such as by surgery, therapy, or diagnosis, this is also excluded.
And those, if I'm not mistaken, are still allowed in certain other jurisdictions, is that right?
Yeah,
okay.
Absolutely.
So, very importantly, who can apply for a patent? Okay, so there's a few individuals and obviously jurisdiction people that can. Firstly, the inventor can apply. Any other person entitled to apply. The inventor or any such person may apply for a patent jointly. So here we have co-ownership of a patent, which is quite common these days. And normally, the inventor would need to assign their rights to the company. And in the form of a university, we are dictated by the IPR Act and the provisions thereof. So any inventor who creates an invention during the course of their university studies will be obligated to assign their intellectual property over to the university, and the university will be the owner and the applicants of the patents, and we will cite all of the inventors who have contributed to that invention or concept.
So when you say that it's assigned to the university, does that leave you with no rights then?
No, not at all. The IPR Act makes provision for a host of rights to the inventor, especially a royalty share upon commercialization thereof. So the inventor is definitely protected, so to speak, and it's well equipped that way. Also, universities have their own policies, which will also prescribe how the inventors are able to derive their share when commercialization of the intellectual property takes place.
Yeah. So earlier, Ursula spoke broadly about patents and said that they're territorial, and she gave a broad description about what can you actually get when you have a patent, and part of that was she mentioned the word monopoly and negative right and all that. So let's dive a bit deeper into what that actually means. So to have a monopoly of your invention means that you've acquired a patent and it's yours and yours only to use. It's almost like insurance. So you take it out and you say, you can't step on this bit of grass, it's mine. If you do, I'm going to enforce it against you because you're not allowed to. So you're excluded from, you're excluding other people from making, using, driving any profits, importing it from it. And then, so at the end of the day, you as an inventor enjoy the whole profit and advantage of your invention, except if you decide to license it out. And there's always a lot of things you can do with it, because a patent is at the end of the day an asset that you have. And like I said, it's a form of insurance that you can also use. It's also something that you can derive money from, like royalties by licensing it out. You can even just sell it outright, assign it, as we spoke about universities and students and lecturers and such. And then when we say a patent is territorial, there's no such thing as a global patent. You don't get a worldwide patent. So for each, the invention needs to be patented in each relevant jurisdiction you're interested in. So if you have a South African patent, you only have the right to exclude people from using your invention in South Africa. It doesn't help you if you don't have a patent in Egypt. They can carry on and use your invention then. So like I said, it's a form of insurance. So if you see somebody is tiptoeing on your grass and you don't want them there, you can institute patent legal proceedings against them. So you can get something like an interdict where you just stop them in their tracks and they're not allowed to do it. And you can also get damages from all the money you have lost, the profits and whatnot that you've lost during the course of them using your idea without your permission and without paying you something for it. Now, one must always remember, that's why you need a patent attorney at all times, is that they can come, the infringer, the person that has now allegedly stole your idea and has been using it, they can then counterclaim for the cancellation or revocation, as we call it, of your invention. So you can lose your patent. That's always something to keep in mind.
So most importantly, and I'm sure you're wondering, how long does a patent last? So the monopoly that is given to you by virtue of this patent statutory right is for a 20-year period. So for 20 years, you have the exclusivity to ensure that no one else can step on your grass,
Absolutely,
so to speak. However, this is subject to the payment of annual renewal fees. In South Africa, the renewal fees are only payable from the 3rd year and every year thereon, but in other jurisdictions, they are paid every year. And in the US, which is quite exceptional, it's in a 3-year term, and it's only paid, like I said, thrice. and that will ensure that your patent is kept in force.
Yeah.
Very importantly, one cannot evergreen a patent, meaning that this lifespan of 20 years cannot be extended further. Once that 20-year period has come to an end, so do your rights. Your rights expire with the expiry of the patent. If you do not pay your renewal fees, the patent will lapse, and so do your rights. In some jurisdictions, and in South Africa, you are able to apply to have your patent continued if you do pay your renewal fees again, and we call it restoration of a patent, and that is subject to certain requirements, and if you do require information on that, we can assist you at that time.
Always.
Okay, so let's talk about when to apply for a patent. It is very important to make sure that you file your patent application prior to any disclosure thereof. Everything that you do disclose prior to filing a patent must be done under an NDA or a non-disclosure agreement. As we mentioned earlier, and as Azan spoke on, disclosure will essentially jeopardize your ability to patent.
Even if you self-disclosed, you've still destroyed your own novelty requirements of your invention, unfortunately.
So any publication that you as inventor at a university makes must be done after the filing of a patent. That is very important. Also, any of your theses that are sitting and waiting to be reviewed should be embargoed until your patent application has been filed.
Even an assignment that you just need to hand in to your lecturer.
Absolutely.
You need to talk to your lecturer beforehand and tell him, I think I've got a good idea. Can we please keep this under a confidential matter that we look at this assignment?
Sure. Once you have ensured that confidentiality has been maintained and everything has been preserved from that end, it would be important to conduct prior art searches, both through patent databases as well as literature searches. You can contact your patent attorneys for this advice. We have very extensive patent searches that we conduct on international databases, but a first step is to ensure from your side that there exists nothing obvious in the prior art that you could be stepping on.
So just when I mentioned I'm in the trenches of patent litigation, so we are quite often in very cool places such as the Constitutional Court. So the first patent case was heard in the Constitutional Court in, I think it was 2018 that we heard, was October 2019 we got the judgment. And that was there, they said that it's important for inventors and infringers to keep on testing a patent. And the Constitutional Court said that it is valid. It is okay to have a patent, but you are allowed to keep on testing it. But the moment you've committed to, let's say you're going to attack a patent on novelty and lack of inventiveness, you can't come back after they found, no, the patent is valid and say, no, maybe it's not actually applicable in the trade and industry or agriculture. So that's just an important thing, and was quite cool that the Constitutional Court found it important enough to have a look at IP law, and especially in patent law.
Absolutely, that's quite groundbreaking.
Yeah. And then other matters were such as the Merck Sharp Dome and Supply Agromed. So it's for two pharmaceutical companies that went head to head. And they also looked at things such as novelty. How do you look at novelty? How do you address it to see if a prior art document is actually novelty destroying? So they said that you don't just need a disclosure in your prior art document. It has to be an enabling disclosure. So if you just have X planted in the prior art document, but that X doesn't say that it gets you to the same results as the same X we have in our document. If it does, then it's enabling disclosure. But if that X just stands there just as a standalone feature of the prior art document, that's not sufficient to destroy novelty of the case. Then we also had a further Merck Sharp Dome matter. So they're quite prolific litigators, fortunately enough, where they said, where we went head to head once again on a pharmaceutical patent. It was actually for Fire Protect frontline that you put on your dogs. So they said that it wasn't obvious, and the Supreme Court's appeal there decided that for it to be obvious, you can't just say that there's an entire pool of prior art documents and you just nitpick your way around it. So the judgment actually starts where you said that if you have a walk through Sherman Forest and you know there's a leaf that you want to have, but you can't immediately find that leaf because there's no goal post that's planted on that leaf. That does not mean that it counts against you as patentee. So that was also quite interesting. So that also aims like exactly like when is it actually there? When does a prior art document embody your invention? If it's just randomly there, that's not sufficient. So then we had a further matter that dealt with the requirements of an interim interdict. So where we say also with the fire protect patent, so the front line, where we got an interim interdict against Siplavet, and they went to the Supreme Court of Appeal, asking them to say no, this is unfair. It's a patent. We won't. You can't give us an interim interdict on an invalid patent, because then we haven't had a look at the validity of the patent yet. So you just had to show that on the face of it, your patent is valid. We got the interdict. The Supreme Court of Appeal said, sorry, you've got an interim interdict, you're stuck with it. So that's also quite interesting. Just because it's IP law, the rules of law don't change, because the interim interdict is generally not appealable. And the Supreme Court of Appeal, they reaffirmed it. There's nothing different for IP matters.
Oh, that's wonderful. IP matters are assessed correctly in court.
Exactly. So just continuing on with some case law, then we also had a few, in 2015, we had a Supreme Court of Appeal case which dealt with, was whether you had to introduce a defense of obviousness if it was not pleaded correctly. So you didn't from the get-go plead it correctly, and then later on you try to rely on it. And they said, at the end of the day, Supreme Court of Appeal, like I said, with any other court case and legal matter, if you don't plead correctly at the start, so if you don't put your defenses and rights in place at the start of the matter, then you can't go ahead, you can't rely on it. So then we also had the Orica Mining Services. So we're now from the pharmaceutical, we've now gone to the mining industry. There they had a look at infringement and how to interpret a patent. And they said that you look at a patent as a normal document, you subscribe the words, the normal meaning of the dictionary words to that patent, and you can't just make something else from it as you wish. It's your job as an inventor to ensure that what you are covering and as your invention is actually recorded in your patent document that you receive at the end of the day. Because we can't see into the mind of the inventor, because it's a recipe that's provided to the public. It's open for the public to look at, so that they know how not to get onto your green grass. However, if you're going to be obtuse and you've got clarity issues, then your patent is going to cause problems for you, and you're going to have a very difficult time to enforce it at the end of the day.
Okay. Interesting. Then
we had the pharmacodynamics case, where they had a look at what we call contributory infringement. There they said that contributory infringement is a very interesting one. We've only had one court case on it. So where you have to show that there is infringement by a party. But if you sell the product as the infringer and you give it in two parts and you provide it to your customers and they build it. So when they build it, they've now got the invention actually as a whole. They're actually also using the IP incorrectly, and that's then called contributory infringement, and you are allowed to go after them. So customers, beware, because it's also not, you can't just lay all the blame at the door of the salesperson. You also need to be aware of what you are doing. That's why you always have to indicate on your product whether there's a patent, so that the public is aware that there's something they need to be aware of at that stage.
Very interesting, and something to be mindful of.
Absolutely. So yeah. So on litigation and the strategy that you use, so that's where it becomes quite fun. So you need to make sure that your patent is in place, and that's nice because when you have a patent and you have a look at it and you see somebody's infringing, you can amend a patent to make sure that it's as strong as possible. So if you are aware that in America they found this portion of your patent to be problematic, we fix it in South Africa, so make sure that we've got the strongest patent available that we can enforce against it. So you make sure all your administration is in order beforehand, you check that your patent is in place, and you need to act quickly sometimes. So you need to talk to your patent attorney as to when you're allowed to start your litigious proceedings. Sometimes it's better to just try and settle the matter. You can see, oh, it's a big corporation or whatnot, and it is expensive, so you need to have those type of discussions as to whether you actually want to run to court. Is it necessary? Do you want to lose your patent? Rather hold on to your patent and give them a license to use it. So there are more aggressive ways to deal with the infringer and more non-aggressive ways. And just because you start by being non-aggressive doesn't mean you're going to end up not being aggressive should it become necessary.
Oh, those are handy tips. Thank you.
Absolutely. So just in general, I've been talking about the courts and everything that we litigate in. So we've actually got a specialized court. It's called the Court of the Commissioner of Patents. But sitting there are normal judges. So it's in the Pretoria High Court, and then they just put on the hat of the Commissioner of Patents that day, that judge. So that's the courts of first instance. That's where we start. So we don't go to magistrate courts. We go immediately to the High Court, which is the courts of the Commissioner of Patents. Then after that, that's when we go to the normal courts, such as the Supreme Court of Appeal, and now recently the Constitutional Court as well. So just to summarize with patent litigation, we've got various forms of legal proceedings that we can institute. So you get something like an interim interdict. They call it an injunction overseas. You may have heard that word before when it comes with Apple and Google and Android and Samsung, all those, they get interim injunctions against each other, and it's absolute wars that are waged. We have essentially the same relief. So if you get an interdict against someone, it's for a set period. And then you can also have an action for infringement that you institute where you get a final interdict. So usually those two run together. If you have, there are certain requirements that you have to meet, but that's our job to make sure that you meet those requirements. And then at the end of the day, the relief that you get, should you be successful, is that you can ask damages from the infringer. So you can say, so one of those ways is we can calculate the damages that if you had not infringed my intellectual property, my patent, what type of license fee would you have paid me if it were to be valid? So there are many different ways to work out what exactly, but there's been some damages awarded of a few million rand. It becomes very expensive, but at the end of the day, sometimes it is worthwhile to do it the long haul. And then lastly, remember, it's appealable. It can go all the way to the Constitutional Court because patents are protected in South Africa, and the persons that are infringing are also protected by the way that they can also go to court. They can apply for the revocation of the patent. Everybody is being granted a fair chance to have the patent scrutinized, and if it shows up under scrutiny to be valid, then that's that.
Wonderful. Well, thank you for taking us through all of that and enlightening us as to the litigation processes regarding patents.
My passion. So
it's a minefield of of things to remember. But thank you. Okay, so our second form of intellectual property that we're going to be dealing with today is what we refer to in South Africa as registered designs. The purpose of a registered design is to protect the visual aspect of an article. So here we look at the pattern, the shape, the ornamentation, and we look at all the considerations given to that article from an aesthetic point of view. Yeah. And we really do look at articles that are intended for mass production. And there are different classes of articles that are protected by registered designs, and depending on what class of article we're looking at, that will form the type of registered design that we will pursue. Importantly, there are two forms or two types of registered designs. The first of which is an aesthetic design. As the name suggests, we're looking at the aesthetic properties given to that article. And the second form of registered design is a functional design. So whereas an aesthetic design is concerned with the aesthetic appearance of that article, a functional design is concerned with the shape of an article which is dictated by the function which that article is actually to perform. Yeah.
So with the registered design, as with patents, you apply per country for it. And then there's only specific countries actually where they also have a thing as such as a registered design. It's not as prolific as a patent and as well known always. You need to obtain your protection separately in each territory. It's also territorial. And then you also have a monopoly that you have in place for that, also subject to renewals, of course. And then basically your requirements there, it has to be new and original for an aesthetic design, and then new and not commonplace in the art for the functional design. So when you get, not as with a patent, you get 20 years. So with an aesthetic design, you get 15 years. So that's your appearance base. Outside, your functional design is for 10 years. That's where it's dictated by the function which it has to perform. So from the date of the application or your release date, so when I speak about a release date, you're allowed, there's a 6 months grace period for registered design, so it's not absolute novelty per se as with patents. So if you've disclosed your idea, you've tested it at a show or whatnot, or exhibited it, then you can, within 6 months from that first disclosure, you're still allowed to apply for the registered design and it won't count against you. And also, as with patents, annual renewal fees are payable.
And can you extend the term of protection that's afforded to you?
Unfortunately not.
Okay, so no evergreening of the design.
No.
So, okay, let's look at a few very well-known designs. And as we're talking about females in IP, just to make it a little bit glamorous, we can look at some of the fashion houses who are prolific design filers. Of course, we all know Jimmy Choo. Not only do they hold global trademarks for their Jimmy Choo trademark, but they also have the iconic Marge sunglasses, and everyone who's in that kind of fashion trend will know which sunglasses I'm talking about. And of course, they filed a registered design to protect their oval shape on the side of their frame, meaning that anybody who wants to make sunglasses having something very similar to that will be prevented from doing so. And they held the monopoly on the runway for this shape on the side of their sunglass for a whole 15 years, meaning that no other fashion house could embark on that. We can also go into sports and sneakers and looking at Nike. Of course, everybody is well known with Nike and their iconic tick. But here we're actually looking at their Flyknit sneaker and actually the sole and the base of their shoe, which has many registered designs that have been filed to protect that. And I know that Puma and Adidas are all trying to encroach on that kind of technology, but so far Nike is holding up there, and thank goodness for their registered designs.
And then we've also got Louis Vuitton. They've got you will all know their monogram that's prolific on all their designs and their dresses, their scarves, their handbags, you name it. Now they've actually got a registered design for that. Also keeping everyone, stay away, this is ours. You know when you're looking at a Louis Vuitton bag or handbag or a dress, you name it, you know immediately. Then we've also got holsters. They've got a well-known sandal, you know, those with the bling on it, and their sole that's very specific. They also have a registered design on that.
Okay, so what are the rights that are afforded by a registered design? So akin to patents, which had a negative right and a negative monopoly, we're also looking at the same type of negative rights that are afforded to design registrations, and thus excluding everybody else who hasn't filed a registered design for that product and that article from making, importing, using, disposing any article which is included in the class in which that design is registered. This means that if you were to register your design in one class relating to, per se, jewelry, but you don't register that design in another class, maybe looking at furniture, and somebody comes about and they start manufacturing the same type of design, but in the realm of furniture, they will be entitled to do so because you haven't got the monopoly that is extended to furniture, but only to jewelry. So with that in mind, it is also quite important to envisage in which classes you would maybe foresee your competitor going into manufacturing, and if it's pertinent to file design registrations in those classes too.
Ursula, if you have a patent, can you also apply for a design?
Absolutely, the two can actually run simultaneously. It's actually quite a nice strategy. Some products would qualify for patent protection as well as design protection. The design looking at the actual appearance of that product, and the patent looking at the inventive concept or the idea, the composition, the makeup, etc. Obviously, the patent would run for 20 years and the design would run for either 15 or 10 years, depending. But they can definitely serve to enhance your protection that's given. And when we look at patents and protection, design protection, and later on we'll talk about trademarks and copyrights, you will see that all forms of intellectual property actually work really well together, so that one can pursue a suite of intellectual property rights.
Yeah, and what's quite cool about patents then, it's not limited to classes as with designs.
Absolutely, that's right. So what is the difference between design protection and patent protection? And this is really what we've touched on now. We're looking at patents which give protection to the actual concept. Again, we're looking at systems, processes, compositions. We're looking at the inventive concept that resides behind the idea. And registered designs are more directed to the visual aspects in terms of the pattern, the shape, the ornamentation, and the configuration.
So the requirements for registrability for a design, for its aesthetic design, it has to be new and original. Functional design, it needs to be new and not commonplace in the art in question. So new is defined as it has to be different from the state of the art immediately prior to the date of the application or your release date of your design, whichever is earlier, important to remember. And we've discussed what your release date is. That's if you've, without applying for the registered design, you've already disclosed it, you've showcased it, but then you still have your 6 months grace period, which is quite nice with what the Act gave us there.
Yeah, that's very handy.
So furthermore, you need to apply for your design before the release date or after the release date within that 6 months period. And if we look at state of the art, as with patents, it's everything that's available to the public anywhere in the world, whether it's written, oral, any way that the matter is contained and it's similar and it shows and it destroys your novelty and all the other requirements of your design.
Okay, so again, similar to patents, we're looking at who can apply for a patent, and here we are looking at who can apply for a design registration. Again, it's the author of the design, and where the author of the design executes the work for another, it will be that other person to whom they did the work for. Of course, there will always need to be an assignment document that needs to be signed, just showcasing that there has been this work that's been done on behalf of the other person. And where the ownership in the design has passed to any other person, it will obviously be in the name of that any other person. Again, looking at universities, we are again dictated by the IPR Act. So any design that an inventor who is studying at the university, if they do design that design during the working at the university, the university will be the owner of that design, and that person will be cited as the author.
Yeah, it's also sometimes you don't always have all the tools to create your design that you've got in mind, and then sometimes you commission someone to perhaps do your CAD drawings of the design. Then you can protect yourself and they just enter into agreement that no IP passes towards the person who creates the CAD drawings for you, or you can come to a different arrangement. But if you don't, there comes some sort of uncertainty, and that can create some problems for you.
And like you said, it's always advisable to address the issues of IP ownership and all the rights pertaining thereto, and all the employment contracts at the start, rather than when things get a little bit too muddy.
Yeah.
Looking at the course and scope of employment, so now this is where you're in the workplace and you design something or you patent something. If that's done outside of your course and scope, outside of working hours, and with no association to that entity, so you haven't used a computer that is owned by that entity or any types of materials, absolutely, then that will be yours, and you will then be able to be the proprietor of that intellectual property on your own. However, if it's done in the course and scope, or if you've used any facilities or, like you said, software that belongs to your employer, that will be the employer's own property.
Yeah. So trademarks, I think that it's quite well known. It's the more hip one. It's not as boring as the others, I think, for some people. So the purpose of a trademark is to protect the reputation of goods, services, or proprietors. And it also allows, its function is to prevent confusion on the part of customers. What am I buying now? Is this an actual Nike product? Is it not? So it allows goods, service, and proprietors to retain distinct identities. And that also makes you more, prevalent in the marketplace and more attractive to eye. So a trademark, in essence, is a mark that is used or proposed to be used by a person in relation to a goods or services, and it has to be for the purposes of distinguishing those goods or services. You can't just have a trademark and then it serves no function. You're just trying to keep everybody else away from that part. And then,
So a mark, it can be any sign that is capable of being represented graphically. So when we're looking at trademarks, it can be a logo, it can be a device, it can be a symbol, it can be a combination of words as well as marks. It can be in different fonts, in different colors. And when we're looking at all of this, we're looking for the get-up, the reputation that you're looking to protect. And we're trying, like you said, to make our services and articles appear distinctive from our competitors by using this combination of words, fonts, colors, marks, symbols. And that's what we're looking to protect with a trademark.
And which is quite interesting is 2 years ago or so, we filed a trademark for Vodafone. So it looks like a comma almost, and it moves and it swirls around, and we got a trademark registration for it based on a 3D configuration that we submitted and a video of it moving, and we got the registration for the movements, how it looks in the beginning, middle and end, and that was one of the first that we got through at the registrar's office.
Oh, that's very, very interesting. I think they must be very happy with us.
Well, we were certainly quite chuffed, I think.
Okay, so the requirements for registrability of a trademark. We're looking at the distinctive nature of trademarks. There must be an inherent ability to distinguish, or there must be distinctiveness brought about through the use of the TM sign. So as you all know, when you're looking at a trademark, you'll see either the TM sign or the R sign in a circle. Yeah. The TM sign stands for a trademark that has been applied for but is awaiting registration. And as soon as that trademark has been registered, you are then able to substitute the TM sign with the R sign in the circle, which now will alert the customers and the public that your trademark has been registered. The date of registration is deemed to be the date of application, so it really doesn't matter as long as you are advertising your services through the trademark with either a TM or an R in a circle sign. Okay, so let's look at a few trademarks that have or have not acquired any distinctiveness. Looking at inventive words, these work the best for trademarks. So we're looking at stowpane. I mean, it's not a word that you'll find in a dictionary, and it has really some distinctive nature, and it's a very successful trademark that is being used. We're looking at slogans, looking good. I mean, that's been something that has really taken South Africa by storm. If you're looking at very, very important and well-used trademarks. And if you're looking at Apple, I mean, they've done a fantastic job. They registered a word that has no bearing on telecommunications, or for cell phones, computers, you name it, even watches. So it really is something that is distinctive. It doesn't describe the service or the article that they are marketing. And so far, they've really done a good job. If you're looking at other trademarks that haven't done such a good job, I mean, Xerox. So everybody calls any printer a Xerox or Xerox printer. So that's
not distinctive.
Not distinctive, and it's actually been diluted with use, so that it doesn't distinguish that company's goods or services. Essentially, it just encompasses any printer by being called a Xerox printer. An escalator is the same thing. So we've really got some good examples of very successful trademarks and less successful ones.
Yeah. So as Ursula was saying, that there are some well-known examples of our trademarks that were very successful. So Coca-Cola is obviously a very nice example. Their logo has been registered as a trademark, as well as the shape of their glass bottles. Then for Standard Bank, their slogan, moving forward, as well as the little design next to Standard Bank, the logo itself. Then Nike, just do it, and the little tick as well. It's all registered trademarks. So as with patents and designs, there are also infringement proceedings that you can institute. So if somebody starts using your trademark, you don't want them to use it, or you think the trademark's not valid, you can also revoke it from the register.
Okay, so you do have a line of defenses available.
Yeah, so it's all very similar actually at the end of the day. It's just generic in certain senses and then more specific. So if you're looking at a trademark query, go to your trademark attorney and not your patent attorney.
There are differences.
And just as a last thing, a trademark is it can be in place, so its monopoly can be there forever. just subject to you paying your renewal
So
fees.
it's a perpetual right.
Exactly.
That's very interesting.
Yes. And even if you don't register a trademark, you can still have a trademark. It doesn't mean it's not enforceable. You just need to jump through some hoops to show that it is yours, it is distinct in the marketplace. So just because it's not registered doesn't mean there's no trademark, hence the use of the TM often.
Wonderful. Okay, so looking at anti-counterfeiting, this is a branch of unlawful competition. And one thing to say is that without a trademark, you will not be able to very successfully defend your get-up, your reputation, as successfully as you would had you had a trademark.
Absolutely.
Think, and we'll take Louis Vuitton again. Think about that brand. If they did not have all their trademarks as well as their design set up, it would be very difficult for them to go after the counterfeiters and try and stop them, try to take away their goods and damage those goods and ensure that their markets is kept exclusively for their own monopoly. Most of the luxury brands, of course, have trademarks and designs in place, and they ensure that the counterfeiters can't as easily manufacture and reproduce what they've got. Of course, it doesn't mean that counterfeiters will no longer be there if you have a trademark or a design, but at least you've got something in your pocket to go after them with. Okay, so let's take us through copyright. As we all know, whenever you see the copyright symbol, you know to beware that there is copyright content and you must not copy this. It is very, very important.
So the purpose of copyright is to protect things such as your literary artistic works, broadcasting programs, computer programs, to protect them from the end of the day from someone just copying them and just taking ownership of something they didn't think of and they didn't design themselves. So with copyright, which is quite fun, there's no registration. You have it automatically. It's yours. If you thought about it and it's original and you actually it materialized, it's not just an idea in your mind, then you've got your copyright. So the specific types, we've briefly mentioned it: music, sound recordings, artistic works such as photographs, films, literary works, raw computer code, computer programs, software programs, broadcasts and performances.
Okay, so looking back at the copyright symbol, this is a statement declaring that the world that the subject matter is under copyright protection, and it's usually used where space is at a premium. Okay, fuller notices detailing the copyright can be then given later on, but it really is there to ward off any potential copiers and to just advise the public that this content is under copyright. Also, if you do not insert your copyright symbol and you do not show that there is copyright work here, it will be very difficult to try and defend your work if there is somebody copying it. So really try and make it visible and in a place where any potential audience can see it. We're talking websites. Make sure it's there and it's seen. If you're doing any 3D graphic prints, or you've got some type of graphics that you're going to give to somebody and you don't want them to copy it, put your copyright symbol on it. It's yours, you own it, and therefore showcase that it is yours. The duration of copyright, it really is determined by the life of the author, plus 50 years if we're looking at literary works, or 50 years from becoming publicly available in the case of computer programs. Very important with copyrights, and we're going back to assignments and the importance of assignments. If you do not obtain an assignment for a copyright work, it will be deemed to be owned by the person who created it. So if you go to a web designer and they create your copyright and you haven't paid for it, so there's no commissioning of it, say it's a friend who's doing a favor for you, they will own that copyright, save for an assignment that's been entered into between you. If you want to get a logo created and you haven't designed that logo, and someone's designed the pictures for you or the artistic work, they will be the owner of that if there is not an assignment document in place. Sometimes those course and scope sort of arguments can also be disputed, especially in the realm of copyright, because it is sometimes very difficult to prove ownership there. And that's why we really do recommend that an assignment document always be obtained in terms of copyright, where copyright is at play.
And important to note with assignment here is that it needs to be in writing and signed by both parties. If you just agree with your friend, it won't be yours. That's not sufficient in the eyes of the law.
For sure, verbal assignments are not what we're looking at here.
Yeah. So the rights that you're afforded is you've got the right to prevent someone from copying it. There are some exclusions which we will discuss, and it's also the author's moral right can't be assigned, meaning this is his work. If he doesn't want to assign it, he doesn't have to. It's his birth child, so to speak. And as with all the other IP, you can ensure that somebody doesn't infringe it. You can go to court. It doesn't matter how small a part has been copied, that can amount to infringement if it is important bit. You need to look at the word substantial. So it doesn't need to be everything, but if it is a small part, but it's a very important part, they're still infringing it. And then also you can seize the infringing materials, claim damages, get interdicts against them, and there are also criminal penalties. Okay. So you need to be careful.
Absolutely. So moral of the story, no copying. And if you want your content to be protected, ensure that all the copyright symbols are in place correctly.
Absolutely.
Okay, so I think what we can also look at now is just dealing with software and just in principle, which is a very important form of intellectual property that links up to copyright. We are aware that it's very difficult to patent any types of software unless it has a technical effect. So copyright really does play very importantly with software. So if there is any source code that you are developing, please be very well aware to put your copyright stamp, to put your timestamp on that work, and ensure that the copyright subsists there. Thank you everyone for participating in this presentation. I think this brings us to the end of today's discussion, but we remain at your disposal if you require any questions or if you want to engage further with Izan and myself. We really are amenable to you speaking telephonically to us or sending any inquiries to us if you want any assistance in protecting or learning more about intellectual property.
This is our passion, and we want this to be your passion as well. And IP is there to be an asset to create wealth, and we want to help you to create a wealth.
Thank you very much for listening to us today, and we look forward to engaging with you further.
Bye-bye.
Thank you so much to Izan and Ursula for putting that presentation together. I know it took a lot of time and effort and a lot of research to put something that is really so relatable together. So thank you so much. We really appreciate it. I found it very interesting, and I'm quite skilled at creating IP and registering it at this point in time. So if I could have learned something, I'm sure that all of you have. We have one question that is IP related that was asked in the live stream or in the live chat. I will get a formal response from Izan and Ursula for you on that. They were supposed to join us on the live chat this afternoon, but then they had an urgent work-related thing to attend to, and we agreed that the top 25 teams, once we have announced them at the beginning of August, will have a live one-on-one Teams chat with Izan and Ursula, and the two of them will speak to you about your specific ideas and help you analyze the specific potential IP in those ideas. So that's a special treat for all of the top 25 finalists, that they will have the opportunity to engage one-on-one live via MS Teams in the first week of August. So if you're a top 5 candidate, we will be in touch in that regard. So tomorrow we have a final day of new content. Tomorrow you consume content in terms of starting a business with your idea. You'll also look at the business model canvas and how to implement it to create a pitch deck. You will use that pitch deck on Friday then to create your video, and you will also use the information to add to the video, to the report that you have already started writing in the design thinking phase of this competition, to create the short report that will accompany your video, your pitch video. So tomorrow, the last day of content. I hope you rest well this evening and that you will have some information, have energy left for that. I see there's one question. I'm just quickly going to read the question and then I will. Okay, and Fencer asked the question about, can you create your own app, or should you logo, or could you use a logo app to generate a logo, and will that copyright then be yours? If you paid for the logo, then sure, somewhere in the terms and conditions there would have been a section stipulating that you will have the copyright to paying for it. I know it's the case when I have some work commissioned on Fiverr. I frequently use designers on Fiverr to do some graphic design work for me, and then typically we have a agreement in place that once I pay them for the work they've done, the copyright is transferred to me. So just make sure that will depend on the app, and it will depend on the paperwork or the terms and conditions that you've seen there. But I think that's a good idea in any case to ask that to Izan and Ursula as well. So I will also get an opinion on this from them. So we have no further questions. So I wish you all a good night's rest. Stay warm, stay safe, and see you tomorrow for your final day of training. Goodbye.